Let me read this should I read the entire title? Okay, no need to read the entire title. Thank you, Mr. Biddle. Okay.
Welcome.
Item 6.1.
If you want to wait a couple minutes, let the room clear. But before I get into it, let me hand out a revised resolution that I've redline, and there are copies that I will leave up here at the dais for those in the public who want it. And let me give you each one.
Hearing. Thank you.
Red line? Do you mean green?
Oh, green.
I'm sorry, I should have given a break. I forgot about that. I count on you to remind me.
All right. Please don't all stand. So this public hearing item relates to the city's development impact fee program. Previously, in the past few years, the council approved 3 contracts with consulting firms to undertake studies in support of amending the existing fee for transportation facilities, as well as looking at the possible establishment of new fees for affordable housing, park and recreation facilities, and government facilities. These fee studies, once they're completed and available for the public consumption, they will be presented to several city committees before they are then presented to the Planning Commission and the City Council for its consideration. This process we anticipate will unfold during the spring and summer of 2014. The item before you tonight is for the council to establish a policy that all discretionary land use applications that are approved by the city will be subject to the development impact fees if they are adopted by the council, subject to certain limitations. First and foremost, let me be clear that notwithstanding what you may have heard from various development interests via emails and what have you that you've received over the last couple days, because I've seen some of them, that the sky is not falling. Similarly, the rules as they exist today relative to the legal ability of the city to impose newly enacted fees on development projects is also not changing by adoption of this policy, with one exception. And that exception relates to the development projects that may file an application for a tentative map or a vesting tentative map. In general, in California, a development project only obtains a vested right to proceed with their project without having to comply with new rules that a city may enact very late in the development process. The California law provides that a developer obtains a vested right upon 1, securing a building permit, 2, performing substantial work in good faith reliance on that building permit, and 3, incurring substantial liability. So in the timeline of a development project, a developer obtains a vested right very late in the process. So they would have filed an application with the city for the various entitlements that they need. They would have undertaken environmental review in accordance with CEQA. The project will have been considered by the various committees that we have. The project will have been considered by the Planning Commission and the Council if applicable. And then they would have, after that, then secured a building permit, and then they would have undertaken work and incurred liability. And it's way here at the end where they then finally obtain a vested right, protecting them from any changes in the rules that the city might impose. This resolution before you doesn't change that rule for the vast majority of development permits that the city processes. There are exceptions to this rule. Government Code Section 66474.2 provides that in determining whether to approve an application for a tentative map, the city may only apply those rules in effect at the time the application is complete. So the determination of whether an application for a tentative map is complete is much sooner in the development process. The application process obviously precedes the environmental review and the formal approval process that I had just talked about. So from staff's perspective, there's a concern that certain development sites within the city could come in, file an application for a tentative map or a vesting tentative map in the near future, and thereby exempt their development projects from having to pay the fees that the city may choose to adopt as part of the fee studies that have been initiated by the city council. I'll also just note there's another exception where the city could agree to a different timeline in the context of a negotiated development agreement, but that is an agreement that the city council itself would have to approve, and so you don't have to worry about that sort of exception coming up and biting you, because a private party cannot force the council to enter into a development agreement. So the issue of concern is these vesting tentative maps, but Government Code Section 66474.2 subsection B allows cities to push this timeline as it pertains to imposition of new fees as to a tentative map to the point in time that the map is actually approved. So you're talking about a point in time sort of switching it from when the tentative map is deemed to be complete to when it is approved. So it would have gone through this environmental review process and this other entitlement process. But there are conditions before that you have to comply with before you can sort of push that timeline back. And that's that the city initiates proceedings to change the rules by way of an ordinance, resolution, or motion, and that the city holds a notice public hearing regarding the nature of the proposed change. So the purpose of this item tonight is to change the rules as it relates to a tentative map. It does not change the rules, as I say, as they presently exist for any other development application. Thus, by adoption of this resolution, the city would be able to impose the new fees on a tentative map or vesting tentative map that are enacted by the city up until the point in time that a map is approved, as opposed to when the map application is deemed complete. I provided to you a revised resolution. During the day, I had some conversations with council for certain of development interests in the city. And so relative to the resolution, first I'll just note that I just sort of, with respect to the title, I tried to shorten it a little bit. And then in the first page, I added some information regarding the impact fee studies that were initiated by the council, because some questions were raised by council for some of the development interests as to whether the city had in fact, quote, initiated the proceedings in accordance with provisions of the government code. So I wanted to add some recitals in here to be clear that the city council did in fact adopt resolutions approving these contracts to initiate proceedings to modify the traffic impact fee and consider imposition of an affordable housing fee, a park and rec fee, and a government facilities fee. And so that first resolve that I've added was just really to affirm that in fact that was your intent in adopting those resolutions and those contracts, was to in fact initiate a process to amend the existing fee program and consider adoption of a new fees for these other programs. And then the other amendment is near the end of the second resolved, which is to clarify that, again, as I said, the new fees would not be applicable to a development project if prior to the enactment, a vesting tentative map had been approved. And then likewise, it made some reference to the fact that the council could itself obviously provide for different rules pursuant to the development agreement if you so choose. So with that, I would recommend that you open the public hearing and consider any testimony from parties that are here. And if you have any questions at that point, I'd be certainly willing to answer them.
Okay, so the public hearing is open.
Hello, Ken Mikowski. I have a few concerns about this. It seems like you're inverting the process. I mean, why don't you go ahead and decide you're going to adopt the fees and then adopt a resolution that, enforces the collection. And then with the subdivision map, I mean, if somebody applies for a subdivision map for a project and then they don't get approval, I mean, how does that factor into the timeline? Would somebody be paying those fees and then maybe not get approval and then have a subdivision that wouldn't be necessarily applicable if the project didn't go forward? So I think when you're going to do a subdivision map, it would be after your project is approved and then you know you're going to subdivide it. So, thank you.
Thank you.
Thank you, Mayor Asher and Council. Bob Cantor with the Emeryville Chamber of Commerce. We are quite concerned about this, and as I hope some of you know, just to put this in context, those who've been around longer, our Chamber of Commerce is not the knee-jerk chamber that automatically opposes everything, and our history is so clear on this. It's wonderful. We have supported the Measure A for the school tax unanimously, our board twice, both Measure A's. When, as we talked about the P-bid tonight, our chamber supported the Emeryville and the P-bid. Most of those property payers are on our board of directors. When the utility users tax had to go before it and you had to get reapproval of that several years ago, we unanimously supported that and others. We do not automatically are knee-jerk opposed to tax or fee increases. We do have a concern here, and I want to compliment Mr. Biddle on his very thorough and very detailed report, as he always does. That's his job, and he did a good job of it. This is our concern. It was discussed this evening in the Emeryville discussion about the regional approaches and looking at things regionally. That's what we always do. In past years, this city has gotten to where it's gotten, in part because you've been better than the competition on both sides of us. That might be changing a little bit now. The cities around us are getting their act together a little more. There was intense competition for the biotechnology industry, the healthcare industry that we're trying to attract. I'm working with Helen to try to attract and retain some of these businesses here. The city of Berkeley has a wonderful new young city manager. She's just like our new city manager here, and she is sharp as heck, and they are going after these businesses. San Leandro is taking a much more aggressive approach. Even Oakland, which frankly I've never had much I'll say respect for their approach to economic development, is getting its act together. We need to think about this. And Mr. Biddle's right, the sky is not falling, but we still need to think about it. Developers look at this. Even just proposing this, and it's going to go to committees and go to the Planning Commission, we understand that. Nothing's going to be decided this evening. But we're very concerned, and we're concerned for our competitive basis. This city has been sharper than the competition. We want to keep it that way. You can never let your guard down. You never hit an apex where you can just stop. You always have to keep looking forward and getting better. It's part of our economic strategy documents. We've produced two. You've both seen them. Most of you have seen them and mostly have liked what's in them. So we just want to, as you consider this tonight, please keep that in mind. Watch what our competitors are doing, and we need to think about that as you go forward tonight. Thank you.
Good evening, Mayor Asher and City Council members. My name is Anna Shimko from the law firm of Sedgwick, LLP, and I'm here tonight on behalf of Madison Marquette, the developer of the Bay Street project. I believe you got a letter earlier today from Cedric Young, who's here in the audience. As I'm sure you know, there's nothing more paramount to developers of property than certainty. Certainty requires bright lines with clear expectations and not amorphous time periods with open-ended and unquantified obligations. I appreciate the fact that Mr. Biddle did adjust the resolution some here this evening in order to reflect the law with respect to vesting tentative maps. However, if the purpose of this ordinance is merely to capture changes that occur between the submission of a map application and the approval of a map, then what I would urge you to do is remove items 2 and 3 in the last resolved clause on page 3 of the resolution. Because what this particular resolution does is allow for the potential imposition of development impact fees that are enacted after building permit issuance, after construction has started on projects, to retroactively go back and impose fees that are newly enacted after building permit application. That's simply not a viable proposal for property owners, and it's unworkable for cities. As to property owners, there's an obvious paramount financing concern. It's simply not feasible that lenders would allow development to proceed with potential plans, given that there would be an open checkbook for fees to come later. In addition, it would be unworkable for the city to have to try and establish when common law vested rights are obtained, when a developer has done substantial work and what that means, when substantial funds have been expended and what that means. It's a potential recipe for discord and confusion where cohesion and certainty are warranted. So I would urge you to eliminate items 2 and 3 in the resolved paragraph, such that fees would only be required that are in place at the time that one pulls a building permit, and no later than that. Thank you.
Anyone else from the public? Yeah,
Jeff White, Avalon Bay. Avalon Bay is a public company. We have one property under contract to develop in the city now and be going through the approval process over the next few months, and we're always looking for new options. I would like to thank council for that very succinct summary, because I think it captures what our concerns are. I'm not sure if the solution is right. Our problem, or our challenge, is having such a short amount of time to digest this, with having really traumatic implications, is what she described is life-threatening to any development. So maybe we've misunderstood it, and we need more clarification. Maybe it's a talk with our attorney, but we at this point in time would say we have severe concerns about moving forward with that change. And again, maybe we just don't fully understand it, but we're not able to support it as of today.
thank you.
Thank you.
Anyone else to be heard? No? Okay, and with that, I'll close the public hearing, and we'll have discussion from...
Well, I'm a little concerned that we got all these markups this evening, so I meant, I'm just concerned that some of the developers might not have got them because they would just received them this evening. So I'd like to just hold this over till next meeting and let everybody make sure that they have seen it.
I'm not supportive of that, because I feel that it doesn't necessarily add anything substantive. It's just giving background information about where how this process originated. So it's simply documenting the history of the process. So I'm very comfortable with the changes that have been made here. Do we have other comments?
I have a question for
Yeah, Nora.
Michael. On the first page of your staff report, at the very end, would you define for me substantial liability? How do you measure that?
How do I measure that?
Well, what I'm saying is, that's kind of loosey-goosey. Substantial
it's what-
liability.
I mean, that is just a recital what California law is. I am using
Oh,
the
yeah.
mic.
He's talking to Nora, I think.
So this is coming out of the state code,
No, it's
substantial
actually more,
liability.
it's common law. And so it's more decisional
Well,
law.
it's
So it's
pretty
going to,
loosey-goosey to me.
it's going to
It's common law.
depend on the individual facts of each individual case. But this, as I say, is a recital of what existing law is. We're not changing what the law already is. So with respect to Avalon Bay, the city could, under existing law, impose a new fee after they've already obtained a building permit. Now, whether they have undertaken substantial work or incurred substantial liability, that's more of a factual determination that would have to be made on a case-by-case basis. What Ms. Shimko has suggested in terms of modifications to the resolution is a change in what is existing California law. Certainly, I understand that it creates a more bright line rule for everyone involved, but I guess part of my concern is that we have had instances in this city, and I'm sure it's nothing unique to Emeryville, where somebody will come in and pull a building permit, and they will sit on the permit and not do any work. And so in that type of situation, that would clearly give the city the ability to say, yeah, we may have issued you a building permit, but you haven't undertaken substantial work in reliance on that permit and incurred substantial liability. And yeah, is it somewhat nebulous, and is it a fact by fact, case by case determination of the facts? Yes, but I think that's something that the city can and should reserve to itself, rather than just creating a bright line rule that says you get your building permit, and then you open yourself up to people sort of rushing to the door, to the finish line, just to get their building permit without any real intent of undertaking work in a timely fashion.
Thank you, Michael. I have another question.
Yes.
Charlie. Charlie, give me a ballpark figure on what percentage, say you have a $50 million project, what percentage of that would go to fees?
So you're saying the
Aggregate
valuation
fee.
of the project is 50 million? Oh, wow. I don't know off the top of my head. I mean,
Not at 11 o'clock.
probably 5 or 6 million, I would guess, but I don't really know off the top of my head. I mean, total fees. You're talking about
That
building,
total fees.
building permit fees, traffic impact fees, art fee, school fees, state building commission fees, all those different things. Well, the building permit fee is 0.8% of valuation, and then the other fees are a percent of the building permit fee, and the other fees are a percent of the valuation, and I don't know what it all adds up to, but, I would guess maybe 5 or 10% of the valuation, something like that.
Okay, Jeff, what do you say?
I thought about 5 or more percent, yeah.
Yeah, okay. What do you say, Helen?
Well, we have done some preliminary work on the impact fee studies, and we have looked at fees in other surrounding communities as a percent of valuation of projects, and it comes, just the impact fees alone are closer to 5%
Okay,
of valuation.
thank you very much. That's what I figured, but thank you all for the input.
Could I ask a question?
Yes.
Of staff? Do all new projects submit applications for a vesting tentative map?
No, they do not.
Do you know how many do?
I don't have any sense of that, but
Not,
my concern is that a project
One
like Sherwin-Williams will,
Uh-huh.
perhaps the Marketplace.
And so this measure that we're considering is really, it's only kind of a placeholder until our nexus study and traffic impact fees are completed and in place.
Correct.
Because once they're in place, then any project that comes forward, whether it has a tentative map or it's a building permit, those fees would be applicable.
Yeah.
So this is, and we don't know exactly how long that'll take. We're hoping to hear back early in 2014. I feel like it's been a year, I guess, some of these contracts that they're working on.
And so the real concern is to be able to impose the fees that the council may choose to adopt on a project that might otherwise choose to obtain or seek a vesting tentative map that are in place at the time that the map is approved, as opposed to when they submit the application and that application is deemed complete, which in the grand scheme of things is probably somewhere in the neighborhood of about a year's difference.
Between when the application's complete and when the application's approved.
Yeah.
Because you're talking about this formal process that...
Well,
that
you have
is
to
that.
go through environmental review, all the entitlement process of public hearings, et cetera. And so for a project, say, the size of Sherwin-Williams, you're probably looking at about a year.
So, and what do you think about the suggestion of removing items 2 and 3 from the 3? These are all and, it's not or, right, for items 1, 2, and
Right,
3.
they're all ands. I mean, I understand the point of view of, from the development side, that it provides some greater clarity that at the time they pull their building permit, that they will know what the applicable fees are. So I appreciate that. But at the same time, that is the suggestion that has been made is really revision to what existing law is. And so I don't see any need for the city to necessarily do that. I think staff has always shown good judgment in the future, or in the past, I should say, about application of fees, and I expect they will continue to do that in the future. And I don't think we're going to sort of willy-nilly start imposing, trying to impose fees on projects where they're clearly well under construction. You know, there could be instances where you know, it's a question mark, and we'll have to vet that out. But I would hate to give up that right of the city, as I don't see any need for you to do so at this point in time, because that sort of risk, that development risk, already exists. It already exists for all these individuals sitting here tonight. And what we're trying to do is close this time period as it relates to a vesting tentative map. That's really all we're trying to accomplish.
So I see our vulnerability just as we're waiting, and it's hard to be patient, frankly. I mean, when we agreed to move ahead with the Nexus study and the traffic impact fee, I just feel impatient. I can't believe it takes this long to have them come forward, because this is critical in terms of our future funding with redevelopment gone. And so I'm in favor of passing this evening.
Is that a motion?
It is.
I second.
You want to take a roll call vote on this?
Yeah, let's call it.
Yeah, let's.
And I assume that's the resolution as modified?
As modified,
Yeah.
please. And I appreciate the clarity. I have to say this was a little bit hard for me to understand too when I first read through it. And I also want to appreciate you noticing all of the significant developers and interests. I know that you felt like you got the notice late, but it's an improvement that you were noticed, I'm just saying.
You got it about the same time you received it.
Yeah, I was wondering what happened to this item.
Councilmember Brinkman.
No.
Councilmember Davis.
Aye.
Councilmember West.
Aye.
Councilmember, Vice Mayor Atkin.
No.
And Mayor Asher.
Aye. Okay,